wanted to basically have this talk about a lot of modern issues that are coming up in advertising online today. First off, I'll introduce myself, even though thank you very much for that. I'm John Monarch. I work with Connexus, Inc. What we do is we are an online advertiser. We own our own products. We also help other companies launch their own products and services online.
My name is Aaron Kelly. I am a partner and attorney at Kelly Warner. I'm also the co-founder of SnapTerms.com, and I also have businesses with both CJ and with John. My firm primarily practices internet law. We handle defamation, intellectual property, FTC compliance, business formation, and contracts. CJ?
My name is CJ Montgomery. I'm both an offer owner and an attorney. I've been an attorney in the space for about 7 years and worked in the affiliate marketing industry as both an advertiser and affiliate for about 12 years now. I largely work as a direct response merchant in the health and beauty niche.
And what we're going to talk about today, briefly, we'll start off with talking a little bit about the FTC, some recent cases that have come through regarding social media compliance as well as with proper disclosures. And then we're also going to briefly touch on corporate structuring, which is one of my favorite subjects, which dives into setting up proper business entities, LLCs, C Corps, and whatnot, as well as having proper contracts with parties. That way, you are operating a legitimate business. So the first thing I want to touch on briefly, these are the three things that we'll be talking about a little bit. Social media. In recent months, we've seen some interesting rulings, not just with the FTC, but in state courts. One of the most interesting was the AdSend lawsuit involving the Washington Attorney General as well as Facebook. And one of the interesting things about that case was the consent decree that came out of it held that the messages that the AdSend affiliates were allegedly posting were to be CAN-SPAM compliant. Now, this isn't binding on everybody. It's just binding on AdSend. But I think we're going to see a trend towards social media messages, i.e., people posting on Facebook about offers being compliant or having to be compliant with CAN-SPAM. After that, we'll briefly talk a little bit about mobile SMS. John will probably touch on that a little bit, just about cramming. We're seeing a lot of these mobile pathway offers that are starting to raise the ire of the FCC and the FTC. A lot of people are moving from regular just offers to mobile offers. And then we're going to touch briefly on online privacy, both having privacy policies, collecting and sharing information, which a lot of our industry is built on sharing information and collecting information, not just for upsells, but just for remarketing, retargeting. So the first thing I kind of want to dive into, this just came out this week, and this is why we had to update the slide, was the DMCA. Google actually made an announcement that they're going to start taking into consideration the number of DMCA complaints the site has received. Now, the DMCA is the Digital Millennium Copyright Act, and what that does is it protects website owners as well as search engines like Google from being sued for copyright infringement. And what they're going to do is they're going to start deciding how to rank sites based on the number of factors as well as the number of complaints that a site has received. And what they're targeting with these that we think are the sites that are selling fake Louis Vuitton luggage and fake Rolexes, but it could end up affecting affiliates and other people in the industry, not just for people that host sites that are protected by the DMCA, but people that use the DMCA as a vehicle to use DMCA takedown notices to take out competition, which I would advise against because the DMCA does have, you have to swear under penalty of perjury when you actually file a DMCA complaint, and you can get in trouble if it's false. So I would advise using that as a vehicle to take out competitors. The other thing that I'm seeing a lot of is the CDA we're seeing a lot of sites, it may apply to some people in here, but the CDA is the Communications Decency Act, and what that does is it protects websites, again, that have like website forums or sites that have a lot of user-generated content, meaning people posting comments or just sites that require a lot of interaction. One of the things that I'm seeing this play a part of is on review sites. So people are, like affiliates are starting up review sites, reviewing multiple products, and they're having comments from multiple people on the page about a particular product. And some of those comments may be real, and some of them may not be. But I'm seeing companies actually file lawsuits now for, against review sites for negative comments that may be on there. And while the CDA may protect some websites, a lot of people think that they would fall under the protection of the CDA when they don't. They create a fake review site and they say don't buy this until you read this site, and they'll review a particular product as well as the competitors' products. One of the cases I recently just handled involved like an iPhone cover, and the site said that don't buy this particular cover because it's bad, it does all these things, but here's some iPhone covers that we would recommend buying, but we don't get paid for any of this, don't worry. I actually viewed the source code, and they were all commission junction links or affiliate links, and so they not only they violated unfair competition law, but they also violated the FTC deceptive advertising law. They've also run afoul of the CDA. So, watch out when you're creating review sites, and making sure that you're only using comments that are from actual people. Which kind of leads into the next part about .com disclosures. The FTC is actually going to be revising these pretty soon. They put it out there for public comment because of changes with social media, using likes and whether or not that's considered an endorsement. And if you remember, the .com disclosures have to do with disclosing a relationship of the site as well as the products that are on the site for sale. So if I have a website and I am an affiliate and I'm promoting a particular health product, I have to disclose on there, if it's a review site, for example, that I'm being paid for. I could get paid for some of the reviews that are on the site or for selling the product. You have to disclose the relationship that you have with the particular product that you're selling. Otherwise, you run into issues of with the FTC Section 5 of the FTC Act with this false and deceptive advertising. But some of the changes that they're making, again, have to do with, at least what we're saying, with testimonials, disclaimers, making sure, when a lot of what the new rules are going to be talking about are social media, but they still apply to sites that are using testimonials. For example, if you have a product that you're selling and you have a testimonial from a person on the page, you have to disclose the fact of, if they were paid, of course, that they weren't paid to provide that testimonial, because it could introduce bias into the consumer's mind when they're buying that particular product. It's also, what we recommend doing is having affidavits from the people that are providing testimonials, and you want to also make sure they're actual bona fide users of the product. I see a lot of people that have websites that they just write their own testimonials and claim that they lost 20 pounds in 3 days. There's an extreme, but they are making up their own testimonials and they're using fake photos that they found on Google Images, which there's so much wrong with that. I don't even want to get started on it, but know that the best way that we recommend for compliance would be to have, if you have paid testimonials, to have affidavits from these people. Also disclose the fact on the page that these people were remunerated, I guess you could say, for their testimonial, which just means that they were paid to provide that. The big thing that I see is, and the reason why a lot of people don't run compliant, is they think there's going to be a huge drop in conversions. I approach this in a couple of different ways, but overall, compliance doesn't always mean that you're going to lose conversions. I look at it like the quality of the conversions you have. So if the more compliant you are, you may lose some conversions on your site, meaning some sales, but the issue is whether or not those were quality. So the people that let's say you had a website before that was a rebill offer that you didn't disclose it was a rebill offer, that they talked about all these dramatic weight loss claims, and these people are going to end up enacting chargebacks anyway. If you run compliant, meaning you have the proper disclosures, you disclose the actual what could happen if if they use the product, the people that are using it, they can now understand what they're buying, which means I think you're going to have happier consumers. And we'll talk about that in a little bit too, about not just running afoul of the FTC, but state, attorney generals, as well as the Better Business Bureau, and just other websites in general that host a lot of consumer complaints. What I tell my clients to do is to monitor, via Google Alerts, their name or their product name or their website on Google, and see what kind of buzz there is about it. If it's nothing, but people saying that your product's a scam or your website's a scam, that's going to carry over into AG, FTC complaints. So just being aware of what is, what's happening and what people are saying about your particular product, your website. Briefly, I'll mention COPA, which is the Children's Online Privacy Protection Act. The reason why I mention that is there are some people out there that develop mobile apps that are mobile games, and these people don't understand that they're targeting people under the age of 13. And the FTC has recently come down pretty hard on mobile developers that were targeting children with their games. And basically COPA says that if you collect information about a person under the age of 13, you have to get permission, and there's a whole slew of other things that you have to do. But just understand that, if your site is geared towards or would be utilized by somebody under the age of 13, that you're going to have to comply with COPA, and it's a pain to comply with COPA. It's very costly too. I know some businesses spend upwards of $200,000 a year on COPA compliance. I'll also briefly mention the California Privacy Protection Act. The reason why I mention that, which it basically has to do with your privacy policies for your websites. I recommend that if your site does sell a product or collect information, that you do have a privacy policy on your website. You're not required, except for unless you target California users or financial information, I think under the Graham-Leach bylaw, you're required to have a privacy policy. But I think in about 2 years, the FTC as well as other agencies are going to require most websites that do collect information to have some sort of privacy policy to let people know what information they're collecting about them. Usually when I draft privacy policies, I look at what's going on in the EU. They have very strong privacy laws over there, about what types of information you can collect and how you can use it. For example, the new UK cookie law, a lot of people that are either in the UK or target the UK have really been confused on what they can do with this new law. Basically, the new law says that if you use cookies on your website for anything, you have to get permission from the person before you actually collect information through the cookie from them. And that also includes Google Analytics. So if you have analytics on your site and you target UK users, or if you're in the UK, you're supposed to comply with the new law. There's a number of ways you can do it. I won't get into it here, but just know that if you are in the UK, a UK citizen, enforcement is a lot easier for them. If you're outside of the UK, it's a lot harder, but they still could come after you. Just like people outside the United States that target United States consumers, the FTC may have jurisdiction over them, but whether or not they go after them just depends on the person, i.e. Jesse Wilms. Next slide, we'll talk about, we're going to just address a few FTC cases really quickly here. The FTC cases that I've seen come out in the past few years, really what interests me are what they're requiring from the companies. And if you ever, read any sort of, internet marketing blog, you read about the fines. And they instituted, a $350 million fine against Jesse Wilms, a $25 million fine against Legacy Learning, $4.8 million against Swish Marketing. We look at these fines, but we don't look at what's underneath, the consent decrees. And the consent decree basically is what the company is going to be having to do for the next 20 years, basically reporting to the FTC what they're doing. For example, a lot of FTC consent decrees with the individual affiliates require those people to report to the FTC, who their current employer is or what they're working on, and they actually monitor them. With networks, they're actually requiring them to monitor affiliates, and if you're an affiliate that is with a network that got hit like that, you kind of wonder, why would I stay with them, because they'll be reporting me to the FTC. So I'm seeing a lot of these consent decrees being very broad, but one of the things that was just in the news recently that was kind of interesting is that none of these FTC consent decrees actually require the company to admit guilt, which they were raising an issue over.
There was an interesting one lately that a lot of you might have seen, that specifically Palm Wonderful, the pomegranate juice company, was sued by the FTC for a pretty hefty amount regarding false claims about, I believe it was cancer prevention of all things. And they had put in $32 million in research was a lot of their claims. But what had happened was in the consent decree, not only did obviously Palm had to pay a fine towards that, but the consent decree attempted to get Palm to not market towards that anymore, as well as they were going to require that they had double-blind, placebo-controlled studies. Well, that's the one section that Palm actually fought and was able to win in court. They were in compliance with the law with the studies that they had, even though they were privately funded and they didn't necessarily follow the double-blind type of situation. Currently, as it stands, supplement manufacturers, providers like that are not required to actually register with the FDA specific studies or anything of that nature. So as a result, in kind of ironic and funny nature, Palm's recent advertising campaigns have actually said endorsed by FTC judge, which that didn't make them too happy.
That was a slap in the face. That was good. The other thing that I would recommend doing is not just keeping up with what the FTC is doing, but with the FDA, FCC. The FCC, they govern, telecommunications, and which means SMS, any type of mobile marketing. Which, if you think the FTC is nasty, the FCC is like the mean big brother, I guess, to the FTC. And some of the things that we talk about with clients is not just paying attention to the FTC, FCC, but also with state attorney generals, the BBB, like I mentioned before, because all this information, I know John might talk about it later, but it all gets aggregated and put into a database called Sentinel. And Sentinel basically has all the consumer complaints from all these agencies in the BBB, and all these different agencies have access to it. I would love to get access to that database. If anybody knows how, I'm kidding. Not really. I would behoove you to, keep your complaints low, because if you end up on that database enough, that's when you can kind of tell when a company is going to be ripe to get picked by, FTC or FCC. And, just briefly, not everybody's going to get hit with an FTC complaint and actual lawsuit, but when they do, this is how it goes. You don't get any notice. They freeze your assets, meaning all your bank accounts, your credit cards. They don't care if your wife has cancer and you need to take her to a hospital, a little ways away, you need money for that. They are strictly business, and they will take everything that you own that was bought with ill-gotten gains, and they'll find out. For example, with Jeremy Johnson's case, if you guys are familiar with him, they sued him, as well as I think 45 or 50 different entities that he owned, as well as entities that his family owned. And just because some of the money that he earned may, you know, have gone to a charity, you know, the Mormon Church, or to, you know, another business. They don't care about that. They will get that back.
They also hit him with the, some of his entities had outstanding checks that were being paid, and when his assets were frozen, those checks bounced. And that was when a writing fraudulent checks charge was slapped on.
Yeah, they just keep tacking it on. But again, you know, not everybody is going to be subject to an FTC lawsuit, but it's better to be safe than sorry. You know, I take a very pragmatic approach to compliance. You know, that it's all about common sense. You know, if the way I usually tell the clients, if it makes you, you know, sleep a little bit uneasy at night, or maybe tingles in your stomach a little bit, and not in a good way, it's usually because you're doing something you shouldn't. And you know, kind of watching over that moral compass is what will keep you out of trouble a lot of times. Also, just briefly, I mentioned it before, you know, the FDA, there's a, maybe I think it was like this year with the HCG. Last year with HCG, yeah. People were promoting HCG as a weight loss product, and the FDA never approved it for that. In fact, CJ, what did they say about HCG?
The FDA considers it basically a falsehood. Despite what the FTC feels about whether you can market or not, the FDA is pretty clear that if you're in the HCG industry, the clock is ticking. It's not a product that should be promoted at all for weight loss.
Yeah.
You'll see many of the products now, what they've gone to is non-hormonal, so they'll call it HCG even though it's not actually in the ingredient list. They skirt around that barely.
And also, a lot of what I'm seeing with diet products is they're not promoting the particular product as much as they are like a package. So they're promoting a weight loss program. So, you know, sign up for this and get our get these magical pills, but then also you'll get enrolled in our weight loss program where we'll send you tips on, you know, how to exercise and diet and not eat McDonald's every day and, you know, work out a couple times a week, as well as sign up for, you know, a mailing list or something, which, you know, that it's not going to completely cover you, but it's better than the alternative of just saying use these pills and lose weight, and, you know, you'll lose X amount of weight per week if you take them. When you package it as a program, you can kind of get around some of the issues that are out there. Go back real quick. Briefly, with just the new biz op rules, I know some of you may promote make money online type offers. The new biz op rules went into effect March 1st, and they're very specific in what they, you know, for example, for disclosure. It doesn't apply to everybody, like certain MLMs as well as coaching programs, but John's had a little bit of experience with
one of the things that I believe it doesn't apply to people who charge over $500 for over, what is it, 6 months? 6 months for their product. And what the program or the new law requirements specifically are is that you have to provide a list of previous customers as well as their full contact information and a disclosure of how much money they've earned using your program, which is pretty in-depth information about it. It also must be in the language that you are marketing in. So just because your offer might be in Polish, you don't have to, you know, if you put the disclosure form in English, it doesn't mean anything. You'll get dinged for that as well. Everything has to be listed out there, and not only that, but with the people that you do list, you have to list a minimum of 10 people if you have that many customers on your business opportunity. And they should be within a regional vicinity of the buyer that may be purchasing it at the time. So if you have, for instance, someone who's interested in purchasing your BizOp in Florida, if you have 10 customers in Florida, you should list them specifically, not some guy out in California or Alaska or whatever, just because it's convenient to you because he had better numbers. It should be regional vicinity.
And then, John, I think we're going to move on to you next.
John,
John,
I'll talk to
CJ.
All right, so now that Aaron scared you with talks of how big the fines get and all these horrible and evil things the FTC can do to you, every company, every charity you've ever been associated with, I'm going to talk a little bit about a couple kind of quick, easy things you can do up front to protect yourself. Being in this space both as an attorney and as an advertiser, I've got a lot of associates that, well, you know, CJ's an attorney, I'll ask him this question. So invariably I get a phone call, CJ, can I get sued for XYZ, whatever their scenario is. It doesn't really matter what their scenario is, because the answer is always yes. You can just about be sued for anything under the sun. I mean, unfortunately, some of these lawsuits are ridiculous. Some of them are, a waste of time, but they're always a waste of money. So the best thing you can do is not so much winning a lawsuit, but to avoid it in the first place. First off, one of the things I see people not do right is having basic contracts in place. This is pretty simple stuff. Paperwork's king in our society. If you're working with an affiliate network, have a signed IO in place. I mean, it seems common sense, and I think these days most networks require it. But in the past, so much of what we do is basically handshake deal that a lot of these things get glossed over. And then someone gets sued for a non-compliant ad, and they say, well, the network said it was okay, or I didn't know the affiliate was doing that. But if you don't have a contract in place, something that says, hey, I'm going to indemnify a network if they get in trouble for my bad actions, then unfortunately you're going to end up with bigger problems than you started with. And most of these contracts don't require incredibly complicated legal terms or hundreds of hours of billable time from guys like me. It's usually something where you just have to have what you're doing listed out on paper somewhere. Signed IOs are the common one. You see those a lot if you work with affiliate networks. It's usually one sheet. It usually says, hey, these are the terms, these are how long it's going to last, this is who it's between, this is what it covers. At a minimum, your contract should cover those, the 5 W's, the who, the what, the where, the when, the why. As long as you've got that down on paper, just the fact that you have it on paper is going to prevent a lot of the problems from arising because there's less confusion. Both sides of the equation know what they're up against and what their duties are. As the slide says, most legal fights aren't over what's in that contract. It's usually stuff that was never discussed or never put down on paper. Both sides of the equation are thinking different things. One side thinks that they're responsible for one thing, the other side thinks that they're not. That's usually where the fights start out. And once litigation happens, both sides have lost, no matter who ultimately loses. So the moral of the story, the goal is not just to win in litigation, is to have your paperwork in order to avoid it in the first place. Regulatory agency avoidance. Aaron's already talked about this a little bit. Obviously, the FTC is the boogeyman to most people. The FDA and the nutritional weight loss supplement pops up a little bit too. When the alphabet guys attack, most government organizations that start with letters are ones you don't want to deal with. If you get sued by a private company, you're usually on you're even footing. I mean, they don't have any distinct advantage over you. Until the courts decide who wins, you're pretty much even adversaries. This isn't the case, as you've already heard from Aaron, when you deal with the FTC or the FDA. These guys, as he discussed, they can do asset freezes. They can force you to sign settlement consent decrees. Sometimes they do criminal. Most of this stuff is on the civil realm, but every once in a while you'll see some of these guys do in fact get criminal charges. But those are pretty rare. Usually it's just on the civil side, but it tends to be very expensive. And you're dealing with organizations generally run by bureaucrats with unlimited budgets and a lot of free time, whereas a private company has to do kind of a cost-benefit analysis to determine whether suing you is worth their time. These organizations don't. State attorney generals have an unlimited budget to protect their consumers. If you've crossed them the wrong way, they can come after you for years and years, and they don't have to show a return. They don't have to win. They just have to drive you into the ground. So, moral of the story on this, anytime these organizations get involved, you need to use an attorney. There's no, you're probably not going to sweet talk your way out of anything once one of these organizations gets involved. That being said, organizations like the FTC don't generally come out of nowhere. It's somewhat rare for somebody to be running their business, minding on their own business, and just wake up one day to a threatening letter or the police at their door. Usually there's some warning signs that if you play your cards right and kind of cut this off at the pass, you can avoid problems with these organizations. Most of these problems rear their heads earlier on. Most common thing I see is BBB complaints. While the BBB has no authority, a lot of businesses don't like them. They're kind of a pest. They're a pain to deal with. And they really have no teeth. There's not much they can do to you. Sure, they can put a little F- on your rating, but most of a lot of people in the online marketing industry don't really care. They don't pay a lot of attention to the BBB. And unfortunately, that's a little bit of a mistake. Because while the BBB has no enforcement authority over you, they usually start what we call a domino effect. If they get ignored long enough and people just keep getting more and more unresponded to complaints and terrible ratings and all of this, they can usually kick it upstairs. Oftentimes, their local attorney general in the state that you're operating in, or in the state that they were operating in, that they're getting all the complaints, but sometimes straight up to the FTC or even the Department of Justice. Once it's in that realm, you're back to the situation where you're going to have to hire legal counsel. You're going to have to fight this uphill battle. And so many companies that end up in this situation could have avoided it by simply addressing it at these earlier stages. If the BBB contacts you, respond. ERSP is the Electronic Retailer Self-Regulation Program. I believe their president is speaking tomorrow. I highly recommend listening to him. He's a very intelligent man. When people like these contact you, that's your warning sign. It's time to start paying attention and do the things you need to do to cut it off at the pass before you have problems with the guys that can really ruin your life.
That's where that Sentinel database comes in, actually, is that a lot of people don't think that they have this, but there's the FTC, all 50 states attorney generals, as well as the Better Business Bureau and other organizations actually do have a database that they share. So if you have BBB complaints, they will show up in there, and they will be in the same database that the attorneys general or the FTC can access, and we'll see if your company has like 20 complaints a day coming in, they're going to know.
And once that ball starts rolling down that hill, it's pretty hard to get it to stop. So the more you can do earlier on to stop this problem and nip it in the bud, the greater chance you've got of not tangling with the guys that can really make life difficult. Next up on protecting yourself up front, the number one avoidable issue I see on a weekly basis probably, and it pains me every time I see it happen because it's one of the easiest things to avoid, is they have no entity set up. People are running as a sole proprietorship. You know, if you're 7 years old and you're running a lemonade stand, a sole proprietorship is great. Run with it. If you're dealing, you know, international and a global e-commerce environment with the FTC and the FDA breathing down your neck and all these various parties looking to sue at the slightest provocation, you probably want a little bit of protection in place. It's a little beyond the scope of today's presentation to discuss the differences between all of them, but generally your choices are going to include C corporations, which is what most people think of when they think of a corporation. The Microsofts, the IBMs, the Nikes of the world are all C corporations. They have stockholders who can make money when the company makes a profit, but they're limited. If Nike goes out and, you know, destroys the environment and I'm a Nike stockholder, it doesn't matter. I shouldn't say it doesn't matter. We don't want the environment destroyed, but I certainly have no legal liability for what that company does. Whereas if you're running as a sole proprietorship, you know, maybe your business only brings in a couple $100s in affiliate revenue a year, but if you've infringed somebody's patent or trademark or copyright law and they sue you personally, they can come after your house, your cars, your bank accounts, and regardless whether you made $10 or $10 million, they're going to seek the maximum that they can from you. So probably the best thing you can do up front if you're in this industry and making really any sort of income is to set up a proper entity. It could be an LLC, it could be I personally like S Corps, which is a variation of the C corporation, but it has a lot of tax advantages once you start making some significant money. But regardless of what it is, your local attorney can probably walk you through it. You know, a Google search will tell you 80% of what you need to know. But at the end of the day, getting this set up early on, not after you've already started making some money, and that's when people get concerned and say, hey, you know, how can I protect myself? What can I do now? Well, your best thing is to start off on the right foot. If you have the right foundation, you're in a lot better shape rather than scrambling to protect yourself once that first cease and desist or lawsuit letter arrives in the mail. So the process of choosing which of these is kind of case specific. I mean, if you're a U.S. citizen, you know, you may like LLCs, you may do partnerships if you have multiple partners. Like I said, I like S Corps, but they don't work if you're using international investors or you've got more than 20, 25 partners. But the goals are very clear. I mean, you want to protect yourself from personal liability in what you do. But there's added bonuses too. I mean, there's certain legitimacy effect you get from being behind a corporation versus Joe Smith. I mean, would you rather do business with Joe Smith or Super Ads Direct Media Inc.? I mean, one of those sounds like a real, well, neither of them sounds like a real entity, but yeah, yeah, highest payouts, no fraud. Simply by doing that, you're setting forth the message that you're taking it seriously enough. It's not something you're running out of your downstairs basement, even if that's how you're running your company. Like I said, that liability protection is key. Some people interpret it as being a little bit more protection than it truly is. If you go up and set a corporation up and pay your $200 fine, and then just keep doing whatever you were doing before, paying personal expenses out of your own account, paying for your dog walker out of the corporate account, things like that can result in what we call veil piercing, which is when someone sues you and says, I know this person's saying they're a corporation and they have the protections of a corporation, but they're really not. They're kind of running around the outskirts and treating it like their personal piggy bank. So in that situation, you want to make sure you're at least following kind of the basic rules to keep that protection. The biggest one is not commingling your funds. Don't run your business checking account out of your personal checking account. Don't pay personal bills out of the business checking account. Those sound common sense, but every time I see some sort of person has been sued personally, even though they had a corporation, invariably they're being lazy. They're not taking these steps to keep the two sides of their life separate. Like you said, think your single member LLC is enough to protect you from civil liability, et cetera. Usually not. Once the corporations start getting pierced, especially by government organizations, that horse has already escaped from the barn. You've usually already done everything kind of wrong to where they got to that level in the first place. So that's why it's so critical to make sure you're doing this from the very beginning and not trying to put it together after the fact. Some states don't recognize a single member LLC as being different from a sole proprietorship, so that's something to be aware of. Every state's laws are a little bit different, so usually it's best to do some research or consult an attorney before you pick a specific entity structure out of a hat. No entity will protect you from criminal liability. Personal liability is one thing, but if you're using a corporation and you're stealing credit card data and sending it to hackers and doing all these things, the fact that you have an Inc. after your name isn't going to save you. Violating criminal law is still violating criminal law. So don't get cocky thinking because I have a corporate setup, I'm not bound by the same rules, particularly as a U.S. citizen, because you are. Which brings us to offshore. A lot of people say, well, my affiliate marketing niche is, shall we say, darker or in the gray area a little bit more. Why don't I just take it offshore? Look at what all these offshore guys can do that I, as a U.S. citizen, can't do. While there's certainly some advantages to being offshore, if you're dealing in the U.S., and most of us have consumers in the U.S., you're probably still going to have to comply with U.S. law. And even if you have an offshore corporate setup, maybe for tax reasons or other liability reasons, for the vast majority of us, you're still going to have to comply with the same rules. And it's pretty easy to get yourself sideways getting offshore corporations set up. I mean, the entity structure is very difficult. It's complex. At the end of the day, if you're not using an attorney who knows what they're doing to set it up, you're probably setting yourself up for failure. So despite how sexy in our industry being an offshore corporation sounds, for most of us, it's really beyond what we should be doing.
So this is where I'll take over a little bit. I want to address some hot topics right now in the industry, specifically glossing over mobile, SMS, private party compliance, especially with things such as merchant accounts. The TCPA, which is the Telephone Consumer Protection Act, which was very recently updated actually, and that ties into privacy policies as well as other data security. Mobile marketing is the one thing that everyone's picking up on now. It's being called the Wild West of the affiliate industry. Back like in 2007, everyone was running continuity. That was the hot thing to go to until everybody got sued. So now that we've addressed that, we think that mobile is probably going to be the next place where there's going to be some severe regulatory action. One of the main things is now that it's the most personal form of communication that most people have. I mean, When you're on a computer, you're just sitting there, you walk up to your computer and you're using it for a certain amount of time, whereas everyone nowadays carries their cell phones with them. So they have unlimited access to market to them. Well, that sounds nice and everything, and when it comes to display, people are opting in. But the FTC itself is now starting to look into better ways to enforce mobile, as well as the FCC. There was a recent article that came out that said the FTC is supposedly limited in its enforcement of mobile because apparently they only have a small basement lab on government networks that can't really see everything. Well, that doesn't mean a whole lot. I mean, they've got the reach, they've got the ability with complaints from, you know, state attorneys general, et cetera, to reach you if you're doing something that's a bit unsavory. Cramming, that's a big topic right now, and actually AT&T, Verizon, and T-Mobile recently shut down several short codes. What is cramming specifically? Cramming is where you take a pin submit type of offer, or where there's a carrier billing submit, and you're passing the information through several of them, so maybe 5 short codes. Maybe these people sign up for one free Best Buy gift card, and all of a sudden they're signed up for $59 a month, and it could have been their kid that signed up for all you know. So even though it might say this is a $9.95, you know, you're joining the joke club or whatever when you submit your phone number, it might be passing through to several other offers, and that's cramming. And it's the functional equivalent of back before there was a strong crackdown, not only by the FTC, but by merchant providers, cross-selling. Cross-selling was going on strongly in 2007, 2008. People would purchase the acai berry product rebill, and suddenly they'd be signed up for the health tracker at an additional $39.95 a month from a different company that they had never heard of, but it was vaguely mentioned in the terms and conditions. That's the same deal here. It's not good. Don't do it. I mean, that's the basics of it. And a lot of times this ties in with the new SMS spamming that's been going on here. So there's 2 different codes that actually cover SMS. First off is the CAN-SPAM Act. If you're sending through carrier mail, which is, you know, the phone number at vzwpix.com, for instance, that's actually considered an email, not just a carrier message. That means that it's covered by CAN-SPAM and the TCPA. So anytime that you have one of these sent, you must have an opt-out, unsubscribe type of, you know, almost a link except a response with stop. And it's the same with the TCPA. It's just that you can get dinged for violation of 2 different codes rather than 1. And with CAN-SPAM, you're dealing with several agencies, the FTC and the FCC, and the TCPA is specifically the FCC. When you are sending over the network, however, that's an entirely different ballgame. Technically, that's not under CAN-SPAM. That's only under the TCPA, which was recently amended to not only discuss SMS, but as well as telemarketing, robo-dialing, and things of that nature. When you violate the TCPA, it is a civil action that can be brought against you, but it has to be usually initiated by the consumer. And it doesn't sound very strong. It says they can sue for at minimum $1 per spam message received. Well, what's happened recently is the major corporations that have been caught violating this, such as Simon & Schuster, which is a subsidiary of CBS, was actually caught sending out millions of spam messages, and they were sued in class action for approximately $175 per message. And they ended up settling for close to $10 million. So it's not really something you want to mess around with too much. Always have an opt-out. If you're getting data, make sure that your data is clean. It's just like emailing, basically. Have an opt-out response with stop. Make sure your data providers aren't some guy off of a forum in Russia that claims it's good. Privacy and data and security issues. Aaron already touched on the COPPA laws for children as well as EU privacy. One thing I wanted to specifically discuss was how, and I'll actually move over to this, for PCI compliance. If you're a merchant and you're selling anything on your website where you accept credit cards, PCI compliance will cover you. It's actually a consortium between a lot of the banks, Visa, MasterCard, Discover, and American Express. What PCI does is it's a standard for addressing credit card inputs on data. Well, anytime you input your credit card number, it needs to be encrypted to a certain PCI standard. if you retain that data, such as not only the card number, but the expiration date, the CVV, security code, it needs to be stored on the server in a specific way. That's why most people usually recommend going with third-party providers for a CRM if it's a hosted off-site type of program. Many times, PCI compliance issues tend to be, it's all privately enforced. So if you end up running into PCI issues, you will usually meet the long arm of Visa, MasterCard, American Express, et cetera, where they come down on you with hefty fines. You lose your merchant account. It can be upwards of $1 million in fines if all of the agency or all of the companies decide to come after you for violations. If you do decide to host on-site, make sure that you have a PCI auditor come in and inspect everything. Not come in, but it can be remote. That usually only costs $200 to $300. I believe that McAfee is one of the companies that does this type of thing too. So if you have a coder, make sure they know the PCI standards and bring everything in and have an auditor inspect everything. Reselling lists of data, that applies SMS, email. Privacy policies have to include if you're going to sell data. It's as simple as that. If you plan on renting lists, selling lists, include that in your policy. And to touch back on the TCPA, the FCC recently updated that to cover robo-dialing, auto-dialing, predictive dialers, and telemarketing. The consumer must know by law that they have opted in to be robo-dialed. This applies for everything except political campaigns. Ironically, the government doesn't like things applying to itself. But what happens basically is in your privacy policy, once they opt in the exact text of it, it has to say that they have elected to receive not only marketing calls, but that these marketing calls may be enforced by, or may be done by robo-dialing. Some things to keep an eye on in the industry. There's legal issues and lawsuits popping up that you should pay attention to specifically. Some new things coming up over the next few months. Specifically, U.S. National Online Privacy Law. A lot of the privacy type of laws are changing, including do not track is getting into a big thing now. Google got sued recently for ignoring Apple Safari's do not track requests. Internet Explorer is now defaulting do not track. So that's going to affect a lot of people with retargeting and things of that nature. FTC enforcement of claims and ads, as we've discussed. Mobile enforcement. Aaron, did you want to touch on the Freely v. Facebook?
Oh, it's talking about using sponsored stories. People are bringing private causes of action against Facebook for using their image and likeness in sponsored stories. One issue that I wanted to address really quick that wasn't on there, make sure you read your contracts that you have, especially network-to-network contracts. Look at the confidentiality clauses in there. Because I see a lot of networks going on Facebook and complaining about not getting paid or so-and-so is a scammer. When you do that, you might be violating your confidentiality provision of your contract. And I've seen some contracts say that by disclosing non-payment that you're actually foregoing the right to get paid. And I've seen that enforced and people losing on that. So before you jump on Facebook or another site and talking about how there's scammers and how you're not getting paid, make sure you know what your contract says first, because you could just be shooting yourself in the foot. If challenged, of course, those probably wouldn't hold up, but I do see them in there. And airing dirty laundry, I never recommend airing dirty laundry on Facebook like that, but just know what you're agreeing to is the overarching concern that I have with people is just reading things before they agree to it. Other than that, that also kind of goes in right into the private scam report sites and defamation. Again, talking bad about another network on Facebook or putting them on rip-off report or a site, even if it's completely true, there may be issues with false light or unfair competition. So don't compete by trying to bring your competition down. Just do what you do best. And if the competition wants to try to drag you down to their level, you have to fight that. But I never recommend going to airing dirty laundry as a way to compete. But I do see it quite a bit.
Quick of things that should be every online business, any online marketer, affiliate, whomever should be aware of. Like Aaron discussed, the .com disclosures, the EU privacy laws, especially in cookies. Those are something that you really want to pay attention to because more than likely the United States will follow. The business opportunity or BizOp law, the TCPA and telemarketing rule, as well as FDA labeling compliance if you're in any kind of nutraceutical space or anything that people ingest or put on their body in some way or form. The way they have those, you actually have to comply right down to the font that you use on your label. And if you're not in compliance, then you can be fined pretty heavily. There's also the CDA, the Communication Decency Act that Aaron mentioned, the DMCA, basically all the laws that we went over earlier. And if you had any questions, we're going to start the question and answer part of this. Please walk up to the microphone. We'll answer anything that you have.
By way of disclaimer, make sure that they're somewhat general questions. While we are attorneys, we're usually probably not your attorneys, and we probably don't have an agreement signed between us. So if you walk up and say, I have this exact situation, we probably can't answer it. If you have a general question, we'll certainly do our best.
I have a friend who...
Me too.
That's my favorite.
Is that okay? Is that better?
Yeah, that's perfect.
You guys could probably talk for hours and hours about this stuff, so I appreciate the concise way that you presented this. I have a question about the terms of use and privacy. I was looking at another company's website the other day, and they had pre-selected I was filling out a lead form, and they'd pre-selected I agree with the terms of use, which I thought was questionable to start. But then when they had the hyperlink to you agree to the terms of use, there was no click-through. But in a general sense, and I think that was a huge problem because I couldn't find it to look at it, but in a general sense, what's the best way to deal with the click-wrap or click-through agreements?
Yeah, the pre-check boxes are a little bit of an issue. It's kind of a gray area. There's no specific area that says the person has to affirmatively do it, but what we call negative option, meaning they have to actually choose not to be agreeing to something, is usually a better way to go. Pre-checking a box, you see it on a lot of offers. The second part of your situation concerns me more. If they're pre-checking something, but there's no link and they're just pre-checking something they can't view, they're going to get shot down. I mean, the first one is gray, the second isn't. If you're saying, I agree to the terms and conditions, which I can't see, and somewhere buried is the terms and conditions say, by using this website, I have the right to your firstborn slave labor for 50. Obviously, that's not going to be enforced. Likewise, anything else they put in there absolving themselves of guilt, if you don't have a way to see it in some reasonably easy fashion, it's probably going to get shot down if they get sued. That being said, the pre-check box, it's gray, but it's used a lot, and so far I'm not aware of any cases where they've said that pre-checking isn't valid.
The FTC says they prefer affirmative opt-in on a lot of theirs. It's one of their best practices list. Yep. As for the hiding of terms part, it has to be, what is it, they call it disclosed in what manner was it?
Yeah, clear and concise, same font. I mean, there's a bunch of kind of guidelines, but most of them are just that, they're guidelines.
Yeah. As far as best practices go, it really depends on what the offer is. I've seen some offers for like payday loans convert really well when they have the actual terms on the page and they have like a JavaScript embed that you have to scroll through. And for some reason, people, if they're agreeing to something where they're receiving money, they like to see a lot of paperwork because they probably dealt with banks before and there's a mountain of paperwork you have to go through. Whereas with other offers, there's been case law out there, for example, with Facebook, where they say, by clicking on the submit button above, you are agreeing to our terms and conditions of use and privacy policy with hyperlinks, both for the terms and conditions and privacy policy. You don't have to have them on the page. In a perfect world, yeah, you should have them presented to the person on the page to give them the opportunity to read them. But as long as if you can log their IP to show that they had the opportunity to review and show that they made the affirmative step in clicking a box or clicking on a box that says, by clicking this, I have read and agreed to whatever it is that they're reading and agreeing to. I've written thousands of terms and privacy policies, and those are the things that I see people get caught up the most in with problems, is not having the terms and the privacy policy on the page, or stealing their terms and privacy policy from other websites. When you do that, it's not like copyright infringement, but you don't know what you just agreed to. You may just agree to litigate all of your claims in, I don't know, Belize or Alaska or something. I've actually, had that happen with clients where they've shown me their terms, and I said, "Are you in New York?" "No." "Do you have any clients in New York?" "No." Or you're getting sued there if somebody does want to sue you. So make sure that if you do decide to draft your own terms and privacy policy, that you understand what you're writing, and don't just copy pasta somebody else's. Any other questions?
Hi there. I'm just wondering, with the whole DMCA thing that you were talking about, the replica sites, I was thinking maybe it would also be very applicable to file sharing sites and intellectual property, but what are your thoughts on that with YouTube? Like, how is it going to affect YouTube and, like, ranking on YouTube?
I don't know how Google's going to...
Right now, Google's, they have a process that kind of streamlined it. It's not the full-blown one you usually have to go through, just because they get tens of thousands of DMCA takedowns of copyright. Every time a new episode of Family Guy or whatever comes on, 50 people load it to YouTube. Of course, the networks don't like that. So they've got a bit of a streamlined process where they can send to Google. And Google doesn't really go through the full review process of a lot of web hosts would. They usually just kind of take it down on faith. Unfortunately, under the DMCA, they have what they call safe harbor provisions, which means as long as you contact a service provider like Google or a hosting company, as long as they take it down, whether it's right, wrong, or indifferent, as long as they take it down within 10 days, they basically can't be sued. Google relies on that as a shield a lot with YouTube. They take down stuff as soon as they get a valid notice, but obviously the problem arises if people get something taken down, they just immediately re-upload it. And Google will continue to do that, but if you're the owner of intellectual property, it's your stuff getting loaded over and over and over on YouTube. It's a frustrating experience because you're sending all this paperwork to Google, and as long as they just take it down each time on a one-on-one basis, they're in compliance with the law. But unfortunately, it doesn't get you anywhere. So the way they've treated it so far is an imperfect way, but a company like Google, or specifically YouTube, relies on user-generated content, so they're not going to make it very hard to load videos. So unfortunately, it falls on the copyright owner to continually send these over and over after the fact, and
it's frustrating.
Yeah, I don't see it changing in the near future.
That's why false DMCA requests are going to be a problem. I mean, someone could file one with Google and they'll just take it down without thinking about it. Yes?
As a website owner or a blog owner, what are my responsibilities as far as what people post? I.e., they say something that the government may be very unhappy with. What are my responsibilities, obligations, and legal issues?
It really depends on the type of site. Like I said before, the CDA, which is the Communications Decency Act, will protect website owners and shield them from liability. But it only does to a certain degree. If, like for example, there's a case involving roommates.com where some of the questions that the website asked kind of forced people to give these defamatory responses. And roommates.com lost their protection under the CDA. It depends on what you're asking people to provide information about, or whether you're kind of inciting defamatory content. Sites out there like Ripoff Report, Complaints Board have been sued, countless times, and they've won every single time, except Ripoff Report's lost one lawsuit in Nevis, and that's it. Other than that, they have complete immunity under the CDA. As far as your website, if it's, comments from people, I would make sure that you do have terms that say, we're not responsible for the claims that, or some of the comments that people make. And then also, just because you don't have liability doesn't mean that people can't sue and subpoena you to find out the information. And what you need to do in your privacy policy is disclose that you do disclose information about the person if there's some type of lawsuit or for law enforcement purposes. Because a lot of times, what I deal with is websites that host content that may or not be defamatory, that we know we can't sue the website, so we'll file a John Doe lawsuit, subpoena that website, and force them to give us the information about that poster. And if you don't have that information in your privacy policy, they may turn around and sue you. Whether or not you'd be held liable, I don't know, but it's important to disclose the fact that you will give up information, because you got to protect your own. I mean, you don't want to just harbor people that are making defamatory comments, but that's really where your liability stops, is at the point of the person making the comment and then you turning over the information if requested.
Yes.
Well, keeping in mind the best way to handle a lawsuit is to avoid one from the beginning, or to avoid getting in trouble with the FTC or those government regulations. If we have a website for our company and we've made our best efforts to comply as well as we understand with the rules, but keeping in mind we're not lawyers, we can interpret things maybe differently than how they're intended. What would you suggest is a good way for us to go about having our sites go through a compliance review or check, both in terms of terms of use, privacy policy, the links that you guys have talked about throughout the presentation? What can we do to find someone who is knowledgeable about this stuff? Because a lot of the legal representations or lawyers who can help us set up a company to begin with, they don't know the ins and outs of the internet world as far as compliance and things that the FTC would want. So what suggestions would you have there?
Yeah, unfortunately, it's somewhat a specialized area. There's lots of attorneys that could run circles around me, and most of the normal things you're going to end up in court in, but they couldn't tell you what DMCA stands for. Or they may have clients that have websites, but other than giving them a default terms and conditions, which they took from offline sources, a lot of these guys, unfortunately, don't really know what they're doing. That being said, there's
a lot of attorneys that are here at the conference.
Yeah, I was going to say a lot of them are here now. You're seeing more and more, but it's definitely a developing area.
Yeah, you definitely want to talk with a lawyer about that. I mean, my firm handles it, William Rothbard, Tom Cohen, Sarah De Diego. There's a lot of people out there that can do these website audits and give you an opinion letter. Now, having an opinion letter that your website's in legal compliance isn't going to save you every time. I had a lawsuit with the FTC where my client gave me 3 different opinion letters, but I said those were all bought on Odesk, and that doesn't really work that way. So just because you have an opinion from an attorney that says your website's compliant doesn't always help you. It has to be from somebody that's competent, that knows this area, that it's not going to absolve you of liability, but it certainly helps mitigate damages. So just do due diligence and look at for an attorney that can help you do a comprehensive review of your website.
Hi. There was some mention made of a movement toward do not track or do not follow on the browser side, and I was wondering if you could just briefly expand upon that slightly. And then in relation to that, could you mention any considerations advertisers should make with those changes?
Monarch.
Well, with the do not track one, actually, Google recently was caught illegally circumventing Apple Safari's do not track rules. And what had happened with that was they were putting a hidden form on there, like many people do on their landing pages or whatever, just to track things on their side. Google was making it appear so that Safari users were actually checking a box and opting in, even though it was completely automatic. Well, they were actually fined by the FTC for this. So even though do not track is still in its very early stages, when you try and circumvent it, you will get dinged pretty hard. So that's kind of an interestingly growing issue nowadays.
So the 2 things I would recommend doing is following what's happening in the EU. Their privacy laws are a lot stronger over there. We're a couple years behind them, as well as following what California does. Their privacy laws kind of mirror what's in the EU. Whenever I write a privacy policy, I always follow the EU and the California laws.
Last question.
How do y'all feel about viral testimonials and then how to get them?
Like paid testimonials, that type of things? Or
Fiverr.
Like Fiverr? Oh. Just really quickly, I know we're out of time, but if you're buying testimonials on Fiverr, like video testimonials, which I see all the time, make sure that you can get an affidavit from them, the person that's doing the testimonial, as well as give them the product that you're selling. Just because you have a video from a real live person that's talking about how awesome your product is, unless they're a bona fide actual user of the product, you may not, you're not complying with the .com disclosures, but it's still kind of a legal gray area. It's a lot better than just making up a fake person that had a fake result, but it's still a little bit iffy. But if you get the testimonial affidavit and send them the product,
You do need to say that they were paid for the testimonial, or remunerated is the term that everyone prefers now. So, thank you very much, everyone.
Thanks, guys.